Attorney John Purton will now begin the formal program.
Good morning. Welcome to our webinar on construction projects in the coronavirus, common issues in construction contracts. Pete Cowan and I are delighted to spend some time with you this morning. We wish it could be in person, but this is the best we could do under the circumstances, and we're glad you're with us. Pete and I spend a lot of time focusing on the construction industry, and we're going to discuss today some of the common themes that we've been hearing, some of the contract clauses that we've been seeing invoked as a result of the coronavirus pandemic, and provide you with some insights and some suggestions for drafting going forward to address not only the current crisis, but the second wave, which we hear may be coming. Our focus will be primarily from the contractor's perspective, but I'd suggest that our observations have equal applicability for anyone who touches a real estate project or a development project, whether it be on the owner-developer side or on the contractor side. In the time that we have, we'll be able to hopefully to sensitize you to some of the issues. And if you have more in-depth questions, we'd welcome the opportunity to speak with you offline. And as Kelly announced just a moment ago, if you do have questions, if you click on the question and answer button and type them in, we'll do our best at the conclusion of our remarks to address those questions. So with that, let's jump right into it. If we could have the first slide. The first clause that we're going to discuss are the so-called force majeure clauses. These are clauses that generally excuse performance of a contract upon the happening of a specified event. And as you can imagine, many parties are now relying on these clauses as a reason why they should be excused from performing in this pandemic environment. Like most people, very few people have paid any attention to these clauses. They are, and most people consider them, what we call boilerplate, just standard legal beagle gobbledygook that nobody pays any attention to. In point of fact, as we now know, and has been driven home rather dramatically, these are very important clauses because they may give you an opportunity to suspend your performance. So let's look at them and how they work. If I could have that next slide, please. What I've put up on the slide is typical language that we see in contracts. This is not necessarily a good or a bad version of a force majeure clause, but we put it up solely so you can see the kinds of things that you'd see in them and get a sense of what they look like. And for many of you, I'm sure this will look familiar. You'll see that in this particular clause, it excuses people from performing as a result of acts beyond their control, acts of God, earthquake, accident, riot, and so on and so forth. So there's a laundry list of things that are out of your control, that are unforeseeable, which, depending on what is listed, may provide a reason to get out of your contractual responsibilities. As I said, most people haven't spent a lot of time negotiating these or looking at these. In fact, I noted in looking at this clause that one of the items listed here is terrorist acts, which is a term that came in right after the 9/11 situation, which was probably the last time anybody looked at these force majeure clauses, and then we started seeing terrorist acts as one of the listed reasons for getting out. 20 years later, we're now going to see some language to address pandemics. The A201, for those of you who use the AIA form contracts in section 8.3.1, also has a force majeure clause, which allows, the standard language allows people to get out of their responsibilities in the events of labor disputes, fire, unavoidable casualties, adverse weather conditions, or other causes beyond the contractor's control. Now, again, generally what we're looking at is suspension of contract performance, but not termination, although the contract clause could be modified if the parties desired to provide for an opportunity to terminate. The thing to be aware of is that force majeure clauses are not standard language. Each one has to be negotiated by its own, and each one will rise and fall on the language that is used. The common themes that we're seeing is, generally speaking, courts will narrowly construe these clauses so that the list, they will look at the list and either you fall within the list or you're not. They will not expand it beyond the verbiage that you've selected. For those catch-all phrases like acts of God or things beyond one's control, again, courts will look at that a little bit with disfavor and try and read those as narrowly as possible. And what they're looking for is, was the event unforeseeable? If it was unforeseeable, then you have a good chance of being within the force majeure clause. Of course, this begs the question, although COVID-19 was clearly unforeseeable the first time round, if there is a second wave, is it still unforeseeable, or is it something that the parties should have anticipated and should draft around? Certainly going forward, you're gonna want to add some language to make it clear that your force majeure or other clauses in the contract anticipate COVID-19 or other types of pandemic. The item that you rely on must be in the list, as I stated, and it must have actually caused your inability to work. If there are other things that prevented you from, the force majeure clause will likely not be applicable. And the final thing that we're looking for is prompt notice. If you are going to take advantage of a force majeure clause, give notice to the other side right away. Obviously, the longer you wait, if you take a wait and see attitude, it certainly undermines your claim that this was something unforeseeable and unavoidable. The mere fact that you're waiting suggests that it might have been avoidable. So if you think you fall within your typical force majeure, you want to give notice often and quickly. So what do we do looking forward? Just as after 9/11, people added terrorist attacks to the list of things which would fall within force majeure, you probably now want to add language such as pandemics, contagions, health crises, epidemics, stop work orders. You want to think about what is it in your particular contract, in your particular situation, that you may cause, that you can't foresee, that you want to contract or draft against. But as it specifically relates to the COVID-19, think about those buzzwords that describe what we're happening today. Stop work orders, stay at home orders, shelter in place orders. Those are all things you may want to consider placing in your force majeure clauses going forward. And then think about, what is the remedy? Is it suspending work for the duration of the contract? Is it broader? Do you want to make it termination, or is it suspension? And if it is suspension, which is typical, are there ongoing responsibilities that are not suspended? In other words, even though you don't have to physically come onto the job site. What about insurance requirements? What about maintaining safety of the site? Who's going to pay for electricity, heat, and utilities? Are there any payment obligations that might continue notwithstanding the suspension of your physical presence on the site? These are all things that you should think about, and these are all things that you want to now think about drafting against as you go forward. What about mobilization and demobilization costs? Pete will speak a little bit about that when he chimes in a little bit, but what are the remedies? Is it just time? Typically, force majeure just gives you time, but not money. Do you want to change that? Again, since these are not standard clauses, they're whatever you want them to be, you have the ability to negotiate. And then the last thing you want to be aware of, and you want to be aware of it now and in the future, and if we could have the next slide, please, is don't forget that your force majeure invocation should be followed by a change order to extend the time of substantial completion or any other deadlines that are coming up. Many of your contracts has a clause in there which says something along the lines of time is of the essence. Again, that's a pretty standard clause that most lawyers and contractors and people don't spend a lot of time thinking about, but this highlights that we should. Time is of the essence means that the deadlines in your contract are hard deadlines, they're important deadlines, and if you miss them, that is a material breach of the contract. So if you invoke force majeure and you suspend the project hand in glove, you want to get a change order that says the parties agree that the time for substantial completion is extended for the duration of the suspension of the project, or words to that effect. So remember, change order is not just scope and money, it's also time. The other thing we're seeing, understandably, are concerns about payment. And if we could have the next slide, please. So in this COVID-19 environment, where cash flow is often tight, are there contract clauses, are there remedies that you have at your disposal to increase the likelihood of payment, or at least put you in first position to get paid once the economy rebounds? We want to just mention very briefly that every state by statute allows contractors and subcontractors, and in some cases design professionals and lower tier contractors, to assert mechanics liens. The rules for mechanics liens vary from state to state, but generally speaking, for those who are unfamiliar with a mechanic lien, it's like an involuntary mortgage, which allows you to literally foreclose, just like a bank would, if you default on your mortgage, to foreclose on the owner's property. In order to do that, there's a bunch of hoops you'll have to jump through, which are set forth in your state's statutes. But the one commonality is you need to have at hand the title reference. You need to know who actually owns the property. So as you draft going forward, think about making a requirement that the owner of the property is disclosed, or that there be a statement that the party you're contracting with actually owns the property, or even get a copy of the deed. Also be aware that typically the time within which to claim these liens is very short, sometimes the periods of 90 or 120 days. So if you're concerned about payment, or you think you might be concerned about payment, that is a remedy you may want to start looking into sooner than later. Typically, liens only apply to private projects, not public projects. However, on public projects, as many of you know, typically there is a requirement for some sort of payment bond or other type of security. So let's talk very briefly just about payment bonds. If we could have the next slide, please. Payment bonds, again, less typical on the private sector, more typical on the commercial side, although in larger private projects and certainly larger private commercial projects, you are seeing them. A payment bond is very similar to an insurance policy. Functionally, it's a pot of money that's waiting for you in the event you are not paid. Again, you may want to think about putting in your contracts going forward that if there is a bond, if the general contractor put up a bond, that you get a copy of it up front so that you know what it says and how to make that claim. Just like the mechanics liens, there are typically very strict timing and notice requirements. Very easy to miss those deadlines if you're unaware of them. So think about getting those up front. And even if your contract is silent, it doesn't pay to ask the owner or the general contractor, if you're a sub, if there is a payment bond in the project, and request a copy. The final thing you may want to be aware of, if we could have the next slide, there are judicial remedies that may leverage your ability to get paid. Depending on your jurisdiction, where the project is, where you're contracting, there are different, what I call tools to get security. all of which, however, require the actual filing of a lawsuit, whereas, for example, liens, at least in the first instance, you don't have to file a lawsuit to claim your lien in the first instance, although ultimately you would have to file suit to enforce it. But we have real estate attachments. Most states allow them, which are similar to liens, where you can actually foreclose on a property if you prevail in the lawsuit. There is ability to freeze bank accounts of the party who owes you money. And there's ability in some jurisdictions to actually reach out and attach money that somebody else might owe to the person who owes you money. The common theme, again, in these potential sources of payment is that you do have to file a lawsuit, and that these are generally discretionary remedies. In other words, the court is not required to give them to you, but it has the option upon your request. And generally, you'll have to convince the court that you have a meritorious claim and that the party who owes you money does not have a meritorious defense. With those tools in your arsenal, you should be well equipped not only to make sure you get paid or increase the likelihood of getting paid, but make sure that if you have to suspend your performance on the contract, that you do it in accordance with the force majeure clause or other clauses in your contract and are well positioned when the economy and the job starts up to seamlessly start. I'm going to turn this over to Pete right now, who's going to talk about some of the other clauses that we're seeing in the AIA form contracts that may become important to you. And just a reminder that even with the AIA form contracts, even though it's a form, when you're negotiating them, you have the ability to negotiate those if they don't cover what you want them to cover. So with that, let me turn it over to Pete, who'll bring it all together for you. Thank you very much.
Good morning. Like John, I'm part of the firm's construction litigation practice group. And I expect, whether as owners or contractors, design professionals, or in some other capacity, most of you are familiar with the family of construction industry agreements, pardon me, published by the American Institute of Architects. Those agreements, or derivations of them, are commonly encountered on construction projects, both here in New England and throughout our country. Now, one document common to those agreements is the AIA A201 document, which contains the general conditions for this family of construction agreements. This morning, I'm going to address 4 separate A201 clauses that you're likely to be encountering, or they're likely to be impacted by the current crisis. Now, as you know only too well, the coronavirus has had an enormous impact on the construction industry, and there's tons of statistics out there, and each of you have heard probably different ones, but I was struck by this announcement last Friday. The AGC reported the loss in April of nearly 1 million jobs nationwide. The Northeast has been hit the hardest, and here in New Hampshire, where I work out of, as an example, we've lost 20% in April. We lost 20% of our construction jobs. Now let's start with our first slide and the first of these clauses. That's the owner's financial arrangements. That's found at Article 2.2 of the AIA A201 document. Now this provides that there are 2 points in the project when the owner may be required to provide the contractor with reasonable evidence that the owner has made financial arrangements that are sufficient to meet its contractual obligations as the project unfolds. Now, the first of these occurs prior to the commencement of the work. And it's a right you have. You don't have to do anything. You can just ask. Now, historically, in my experience, it's something that people typically have not availed themselves of. It's maybe like force majeure, as John was alluding to, in the sense that it's a clause that exists, it's there, but nobody pays much attention to it. Now, these days, contractors certainly should ask, because whatever the conditions were before, whatever, however solid your owner was before this pandemic, those things have been called into question, and so you should ask. And owners, you should be prepared to to have that asked of you and be prepared to respond. The second point in a project which you can make a request for this information is after the commencement of the work. But there's a requirement you have to satisfy first. You can only make that request and obtain that information if, in the language of Article 2.2, and this is a quote, the contractor identifies in writing a reasonable concern regarding the owner's ability to make payments when due. I think it's safe to say that the current pandemic supplies the necessary reasonable concern to support such a request. Now, let's say the contractor makes the request and learns that there's problems with the owner's financing. What then? Well, Article 2.2 provides that the contractor is entitled to three things. First, he can immediately stop performance of the work. Second, he can receive an extension of time for the stoppage period. And third, he's entitled to an increase in the contract sum by the amount of the contractor's reasonable costs of shutdown, delay, and startup, plus interest. So that really takes care of 2.2. Let's turn now to the next slide, which is labor and materials, Article 3.4. This section of the A201 obligates the contractor to provide and pay for the materials and labor necessary for proper execution of the work. Now, as I'm sure many of you have already experienced, the coronavirus pandemic has wreaked havoc on the supply chain. And this has resulted in shortages or unavailability of the construction materials required for proper execution of the work. Now, particularly in a GMP contract, the contractor is most likely not entitled to a change order for the increased costs associated with obtaining the specified materials. Let's say they're still out there, there's a shortage, the price has gone up. You're not entitled to a change order for that increase in cost. However, an owner's need to adhere to the project schedule may offer contractors finding themselves in this situation with some leverage. Because referring again to the A201, under Article 8.3.1, the contractor will probably be entitled to an extension of time until the specified materials become available again. And so in a situation where they're actually unavailable, the contractor can secure a change order for an extension of the contract time. So if the contract completion date is crucial for the owner, then the owner may have to be more flexible and absorb these increased costs or accept lower grade materials if he wants to stick to the project schedule. Conversely, owners may need to re-examine the importance of the contract completion date, and they may need to sacrifice time in order to get the product that they originally contracted for. So that's likely to be a choice you're going to be encountering and a struggle that you're going to be seeing on projects going forward. Now, just as the pandemic has impacted the availability of materials, it has also impacted the availability of skilled workers, supervisors, laborers needed to perform the work. Now, should contractors encounter labor shortages, they most likely, in the ordinary course, would have to bear any increased cost, any premiums they had to pay in procuring that labor. If the owner wants to stick to the schedule, in certain circumstances, under Article 2.5, the owner has the right to hire the labor and charge those costs against the contract. However, those circumstances in which the owner can do that are limited. First, the owner must be able to show that the contractor's actions constitute a default under the contract or neglect by the contractor to carry out the work. So it's really not an open-ended right, but if in the right circumstances, that is a remedy that the owner has available to it if it's not satisfied with the progress of the work. Let's turn to the next slide, please, and that's going to be Article 10, Protection of Persons and Property. With the advent of the coronavirus, this obligation reaches beyond the typical risks that contractors encounter on construction sites all the time. You know, whether it's heavy equipment, the conditions on site, added to the list now of these typical risks is the coronavirus. And it's incumbent on the contractor to establish programs and practices that are designed to keep employees safe from the coronavirus. And I think it's safe to say, although I've not seen any decisions, deciding this, that clause would be interpreted at this point in embracing that new obligation. So owners need to be vigilant to make sure that their contractors are taking appropriate measures to maintain a safe job site with respect to this new threat. At this point, the contractor's safety obligations now extend to programs and other measures that are designed to keep workers safe from infection by the virus. And these measures include concepts that have become all too familiar to us, things like social distancing, limiting the number of personnel on site, perhaps limiting the number of people who can assemble in a group on site, staggered shifts, and other measures, all designed to manage, not eliminate, but manage the risk of coronavirus infections. And I think, as suggested by my prior remark, this responsibility is not a strict liability situation, but the new reality is that contractors have these additional responsibilities to adopt measures that are reasonably designed to mitigate this risk. And I should add that this responsibility extends to compliance with orders issued by public officials at the local, state, and federal level. Let's turn briefly to termination and suspension. That's Article 14 of the A201. As a general matter, and I know a lot of people would say it's no surprise because the AIA documents are, I think, commonly regarded as owner friendly. But as a general matter, the owner has considerably broader rights than does the contractor when it comes to termination and suspension. And however, although the contractor's right to terminate is much more limited, the contractor does have broad rights to receive time extensions where warranted. Now, under Article 14.1.1, if the owner keeps making timely payments, the contractor must continue performance. There is an exception, however, and that exception is if there's an order of a court or other public authority having jurisdiction over the project, or an act of government that requires all work to be stopped, then of course a contractor may cease work. For example, if a federal, state, or local authority imposes requirements that prohibit work on a project from proceeding, as recently happened in Boston, where I believe it was the state that stepped in. It may have been the city of Boston, I'm not entirely certain. But in either case, that's the kind of order from a public authority that can cause work to cease, and that's what happened there. And I believe also in some adjoining communities like Cambridge. By contrast, the owner has the right to suspend or terminate the work for convenience and without cause under 14.3 for suspension, under 14.4 for termination. So if the work is suspended for the owner's convenience, the contractor is entitled to adjustments to the contract. He's entitled to adjustments both to the contract time and to the contract sum for the period of the delay. Under a termination for convenience, the contractor receives three things, well, actually two and potentially a third. He receives reimbursement for the work performed, reimbursement for the costs incurred to date, and where it's provided for, may also receive a termination fee. Now, if the contractor is terminated, the contractor must cease performance and cancel subcontracts, and there's all the attendant concerns that go along with cancellation of the subcontracts. So Why might the owner choose termination over suspension? And certainly one answer is as follows: to manage general conditions, because those costs would continue to accrue indefinitely if an owner suspended rather than terminated. Well, that's it for my remarks this morning in this quick summary of some of the AIA 201 provisions that you may encounter in projects now and going forward. Thanks very much for tuning in, and this concludes our formal program. We'll now turn to a few questions from the audience.
So we do have a question posed, and Pete, I think this is largely in your arena, but we can try it together. The question is that in accordance with Article 10 of the A201, what are the owner's responsibilities for protection of the contractor's employees? So in other words, if the owner is aware that the contractor is not being safe, does the owner have any independent responsibilities? And I guess I'll give Pete a second to think about it, but my initial gut reaction to that would be that in the first instance, under the AIA, the contractor is responsibility for safeguarding his employees and his responsibility for the site on any circumstances. Certainly, if an owner is aware, the owner should certainly give notice, but in the first instance, safety of the project site is the contractor's responsibility. But again, I don't think that an owner can, effectively bury his or her head in the sand if they're aware that these safe practices are not taken care of. However, the owner also doesn't want to become the police person. If the owner does become aware, your job would be to let the contractor know, and then the responsibility again is on the contractor to figure out how to do means and methods and ensure a safe work site. And if they don't, then the owner has options perhaps to default or terminate. So Pete, I don't know if you have thoughts on that as well.
Well, I think, John, you covered it pretty thoroughly there. I think the owner, it's hard to say. It would take, I think, an extreme situation for liability to reside with the owner. And certainly in the first instance, it's the contractor's responsibility. Having said that, the owner's got easy availability to protect him or herself by remaining vigilant, by if the owner is aware of situations that aren't just random or occasional, but if there's a pattern of really irresponsible behavior as defined in these current, this current environment by the contractor and failing to take appropriate measures, then the owner ought to exercise the tools that it has under the contract to insist that the contractor comply with its obligations. And I think if an owner does that, then they're probably in pretty good shape.
Okay, so that seems to conclude the online questions. If you're like most people, think of all your questions as soon as we sign off. So we certainly invite you to contact us or any member of the firm should you have other questions. We greatly appreciate you taking time to be with us this morning and hope we've at least sensitized you to some of the issues. And we look forward to speaking with you and seeing you all in person as soon as we're able. Thank you again, and we wish you a great day.
Thanks very much, and stay safe. Take care.